And this is regarding the Planning, Environmental, and Development Services Department. Conversation about split oak that has been invoked many times today. I think about 30 people or so spoke about split oak. And this is an update. We're going to have Beth Jackson come forward. She's going to lead us off, and then we'll go from there. All right, with that, you're recognized.
Thank you, Mayor. Mayor and Commissioners, I'm going to provide you an update and work session on Split Oak Forest and Osceola Parkway Extension. So today we're going to cover quite a few items. In the background, we're going to provide some information on the Split Oak Forest Wildlife and Environmental Area, cover the December 17th, 2019 BCC resolution, the November 3rd Charter Amendment, and then we'll provide you with updates on agency actions regarding Florida Communities Trust, the board action that was taken on November the 28th, Florida Fish and Wildlife Conservation Commission, as well as Osceola County's statement that they made to us. Then provide you a current status and request some board direction. So Split Oak Forest is a conservation area. It's 1,684 acres in size. 1,004 acres is in Orange County and under the fee simple ownership of Orange County only. Osceola County does not have any interest in our title. Osceola County owns 685 acres. They are the fee simple owner. We do not have any interest in the lands that are owned by Osceola County, any interest in the title. It was acquired in 1994. We were awarded a grant by Florida Communities Trust. The purchase price was $8,613,697. So the grant and interagency agreements were executed. Florida Communities Trust provided $3,631,697 of the purchase price. Orange County's commitment was 2.3. Osceola County's was 2.7. And then both Orange and Osceola County entered into an interagency management agreement with FWC to manage Split Oak Forest. So there were easements granted both by Orange and Osceola County. Orange County has granted an easement to FWC. We are the sole grantee on that easement to FWC. Osceola County has entered into similar conservation easements with the Florida Fish and Wildlife Conservation Commission. We are not part of those easements. They've also entered into easements with South Florida Water Management District. And then the management, again, as I stated, Split Oak is done on our behalf by FWC. So the purpose of the acquisition was for wetland permitting mitigation. Orange County, we paid for the property through a bond. So in order to pay back that bond, we had a mitigation bank with South Florida Water Management District to sell mitigation credits. It's to conserve natural and cultural resources, preserve suitable gopher tortoise habitat, provide nature-based recreational experiences, and the environmental benefits. It does protect a diverse range of natural communities, both imperiled plant and wildlife species, and it's designated as a Florida National Scenic Trail, runs through there, as well as the Great Florida Birding and Wildlife Trail. So on May 2022, CFX passed a resolution in support of the Split Oak minimization alternative. Within that resolution, it stated there's no impacts to Orange County Split Oaks portion. 1.3 miles of proposed expressway crossing through Osceola County at the southern corner of Split Oak Forest. There will be 60 acres of direct impact. from the proposed Osceola Parkway extension. And also included in that agreement was the $13 million for the restoration of the habitat and hydrological restoration, as well as a commitment by CFX that they would not expand the Osceola Parkway extension through Split Oak in the future. So in December 17th, 2019, Orange County and CFX provided a presentation to the board on the reevaluation and Split Oak minimization alternative. So just to clarify what's meant by reevaluation, prior to CFX assuming the responsibility for the Osceola Parkway extension, there was a previous PD&E study that was approved by Osceola Expressway Authority, which actually went right through the middle of Split Oak. So the board approved the resolution by a 5-2 vote, supporting CFX preferred alternative for the Parkway extension and environmental study. It approved amendment to agreements to allow a new easement of approximately 60 acres for the Parkway extension in Osceola County, authorized staff to coordinate with Osceola County and CFX, and it approved the submission of an application to the Florida Communities Trust for a linear facilities determination. So the CFX Osceola preferred alternative minimizes impacts to existing and future residents and the environment. Proposed extension has no impact on Orange County's portion of the Split Oak Forest, and it included the ability for the Orange County to receive 968 acres of donated lands. All of the impacts from the Osceola Parkway extension are located in Osceola County. CFX identified that preferred alternative as part of the PD&E reevaluation study that no longer contained any direct impacts to the conservation easements lands located in Orange County. Approvals contingent upon Orange County's acceptance of the additional 968 acres, and the resolution was required as part of the FCT linear facility determination application. I just want to inform the board that none of the easements within Orange County's portion of Split Oak will be released. They will remain intact. So I'm going to provide a brief overview of the proposed donated lands. It's 1,550 acres within Orange and Osceola County, 968 acres within Orange County, 582 are located within Osceola County. CFX is proposing to provide $13 million to FWC for restoration and management of those lands, both habitat as well as hydrological restoration. So if you look at the monies, it breaks down to $8,387 per acre. And the monies will be used by FWC for management and restoration. So the communities that are found in the Orange County portion, the natural communities are Cypress Swamp, Mesic Flatwoods, Mesic Hammock, Wet Hammock, and mixed wetland hardwoods. There is approximately 230 acres that does require habitat and hydrological restoration, and those are considered rural communities of improved pasture and old orange groves. So some of the benefits of preserving the 968 acres is it is designated as a critical wildlife linkage for the ecological greenways network. It will provide water resource protection, provide a buffer from development, and provide nature-based recreational opportunities. That's just some of the potential benefits. So in 2019, we had informed the board that these were potential next steps that would have to occur. An amendment to the existing Florida Communities Trust Grant Award Agreement an amendment to the interagency agreement, the current one over Split Oak Forest, enter into a donation agreement to accept the 968 acres, enter into a new interagency management agreement with FWC for the donated lands, placement of a conservation easement to FWC over the donated lands. And one of the things that we do when we preserve our environmentally sensitive lands is we work with our planning division to change the future land use to preservation as well. So in November 3rd, 2020, the Split Oak Forest Wildlife and Environmental Area Charter ballot provision passed by 86%. There were prohibitions to that promulgated under Section 1000.01, and the charter prohibitions will not apply to any action, negotiation, amendment, modification, agreement, ordinance, or resolution entered into or undertaken that provides greater, additional, and or more stringent protections for the wildlife, vegetation, and environment, or the preservation of the use of Split Oak Forest as conservation land. The restrictions centered on the amendment of the grant award agreement and an interagency management agreement. So we do have the Orange County Attorney's Office here for any questions you might have on these matters. The consideration of the amendments to the FCT grant award agreement and interagency agreement by Orange County would require a determination of whether the proposed amendments are strictly prohibited by the charter or allowed as an exception because they afford greater or more stringent protections to Split Oak. So litigation is pending between Osceola County and Orange County challenging the validity of the charter amendment. There's no trial date set at this time. A hearing is scheduled for February the 19th on Orange County's motion for summary judgment, and the court's determination on the motion for summary judgment or the verdict at a trial if the motion is denied is unlikely to impact the Osceola Parkway extension itself or what matters are considered by the BCC. So now we're going to go into the agency updates. The first thing is the Florida Communities Trust. Based on the direction of the board provided in the resolution of 2019, Osceola and Orange County applied to FCT for that linear facilities determination on May 8th, 2020. July 30th, 2020, the counties received a request for additional information from the Florida Communities Trust staff. October 23rd of 2020, the county submitted a response to the RAI. On April 20th, 2022, the FCT Governing Board approved the linear facilities determination. The proposed Osceola Parkway extension would directly impact 60 acres within Osceola County's portion of Split Oak and indirectly impact 100 acres south of the Osceola Parkway extension. And those are the acres that FWC has said they no longer wish to manage. They will manage the rest of Split Oak Forest as well as the proposed donation lands, but they felt as though the expressway would impact their ability to provide the appropriate management. And the Florida Communities Trust Governing Board unanimously approved with the following conditions. Counties must advise if they will accept title to the proposed 1,550 acres of donated lands. That's pending. Counties must provide a survey, environmental site assessment, and title work for the donated lands. Survey and environmental site assessment has been completed. The title work has not been completed. It would have gone out a date. You need to do those things close to when you're going to close on a property because they look for liens and things of that nature that may impact the potential future owner. Counties must describe how the donated lands will be managed and by whom. Counties must provide a revised management plan adjusted to account for the linear facility and incorporating the additional property into the Split Oak project. Counties must provide draft easements for 60 and 100 acre proposed for impacts. Even though it says the counties, that's really Osceola County. They will be providing an easement to CFX for the 60 acres of direct impact. And then they propose not to release that the easement that's already over the 100 acres. They only want to partially release some of their conservation easements that are direct within the pathway of the proposed Osceola Parkway extension. Osceola County must provide documentation to FCT that it satisfied its outstanding mortgage at the time of the purchase of Split Oak. Osceola County did not have the sufficient funding to purchase the property, so Florida Communities Trust provided those funds and they paid them back. They've done that. And the counties must obtain a release of easements held by FWC and South Florida Water Management District that are not consistent with the expansion of the Osceola Parkway extension. Again, although it says counties, we are not part of the easements that Osceola County granted to FWC and South Florida Water Management District. So they are the ones that are going to need to negotiate those releases. And so on November the 28th, 2023, the board took the following action. By 6-1, you approved a motion that given the prior charter amendment of vote of 2020, the board no longer supports the pending application before the Florida Fish and Wildlife Conservation Commission and Florida Communities Trust. So, giving you an update on the Florida Fish and Wildlife Conservation Commission. In the summer of 2023, they tentatively committed to managing the 1,550 acres in Osceola and Orange County. So prior to that, we were under the impression that both Osceola and Orange County may have to take the management lead on those donated lands. So we would have had to enter into an agreement with Osceola County to divvy up that pot of money. So on December the 5th, the FWC Commission was provided a presentation on Split Oak Forest and Osceola Parkway. The Commission voted 6-0 to direct FWC staff to continue discussions and negotiations with the counties on the release of the easements and provided explicit direction that the decision on the release of the conservation easements should be brought to a future FWC Commission meeting for final action. The next FWC, they just published the agenda, and this item is not on that agenda. So after that meeting, and based on the vote that the board took on November the 28th, Osceola County informed Orange County staff that they are willing to accept the entire 1,550 acres in both Orange and Osceola County and enter into an interagency agreement to manage those lands with FWC. They have also indicated that they would potentially be willing to transfer the title to Orange County if so desired in the future. Future board actions would be required to facilitate this potential transfer. So now up to current status. So remember how we had informed the board at 2019 that we felt as though we would have to amend the FCT grant award agreement, as well as the interagency agreement over the existing Split Oak Forest wildlife. But based on direction from FCT, these items are no longer required. What is still required is the donation agreement to accept the 968 acres of donated lands within Orange County, an interagency management agreement with FWC for the donated lands, and a conservation easement granted to FWC and FCT over the donated lands. These agreements could be entered into by Osceola County, thus satisfying the conditions of the FCT approval that occurred on April 20th, 2022. So FWC's decision is related to the release of conservation easements for impacted lands in Osceola County, a condition of FCT's approval of the linear facility determination. Depending on the final decision by FWC, no board action may be required regarding OPE and split oak forest. FWC meeting on I already alluded to that. They did publish the agenda today, and this item's not on there. So the board 2019 motion to no longer support the FWC and FCT application raised some key issues for us. How should staff engage, if at all, with FCT, FWC, CFX, and Osceola County? Is the board comfortable with Osceola County owning the 960 acres of donated lands in Orange County or entering into an interagency agreement with FWC, which Orange County would not be a party to? Has the board's 2019 position to support owning the 968 acres to be placed into conservation changed? And should staff negotiate an interagency agreement with FWC for board consideration if the board decides to accept the 968 acres? So we have some board discussion items. So we're seeking direction pending the FWC's decision related to the release of conservation easements for a portion of Split Oak and ownership of proposed donated lands in Orange County. Remember, we're not a party into those conservation easements that are going to be potentially released by Osceola County's requesting that they be released to FWC. But we do need to have some idea about the interagency management agreement and ownership of lands in Orange County. We need some direction on staff engagement with FWC, FCT, CFX, and Osceola County to enter into new agreements for the donated lands. Osceola County's offer to accept the title to donated lands in Orange County, and a determination of whether the proposed amendments are strictly prohibited by the charter or allowed as an exception because they afford greater or more stringent protections to Split Oak. And that concludes my presentation, and I'll be happy to answer any questions you may have.
Beth, go back to the slide on the current status. Let me just understand that one. The one that starts with board action. Board, let's see.
Just let me know if I'm hitting it yet.
I think there, right there.
Right.
Okay, so should that first bullet be
It
the
should be
2020-23 motion?
Yes, sir, it should.
Okay.
Sometimes you get so used to looking at presentations that you...
Okay, all right. Okay, I was just trying
Takes
to
a
follow
village.
what you were saying there. Okay.
Yeah, I
And so
apologize.
that's the central issue
Yes,
that
sir.
is before us now is, this conversation has to be kind of centered around this slide and that bullet has the board's 2019 position to support owning the 968 acres to be placed in the conservation change. That's a key question.
Yes, sir.
In this slide.
Right.
That happened in 2019. The motion on no longer supporting it happened in 2023.
Correct.
Okay, and so we can open it up for any questions, comments at this time, and we'll start. Commissioner Wilson.
Thank you, Mayor. Thank you, Beth. Thank you for to the public that came out to speak today. And I like that you're there, but I'm going to direct this one over here. We're currently operating under this charter amendment, correct? This has not been invalidated by any court in the state of Florida.
That's correct.
So understanding that what the charter amendment requires is that this board not take any action to, it's right in front of me, that we're restricted
Right.
to amend, revoke any critical provisions of the grant award agreement. And that we cannot enter by vote, consent, or otherwise, right? So even if we have, even a consensus potentially could be something that would be prohibited.
Correct.
Okay, so then the crux to this charter amendment is, or the argument that you could see being made, is either the exception, which is that that entering into this new
Provides greater protection.
yeah, anything that provides greater protection, right? So if it's something that
Additional.
provided greater protection, that we would be able to do that and modify this agreement. This does not. I think that there's some discussion that came up about the donation, but I want to actually pivot on that thought for a second, because the word donation is used in a private agreement between Tavistock and CFX. We're not party to that. We have nothing to do with that. It's used again, I believe, in an agreement between Tavistock, Suburban Land Trust, and the Lake Mary Jane neighborhood. Once again, we're not a party to that. But the legal definition of a donation is a voluntary transfer of property from a donor to a donee with no exchange of value on the part of the recipient. So let's just call it a contingency, because that's what this is. And it's a contingency that we are not a party to in any of the agreements that they are negotiating, which puts us very wrong-footed in so many ways. What we are a party to, and what we do have an obligation to, of course, is this charter protection, and understanding that the grant award agreement requires all parties to the agreement to amend the agreement. And what I'm trying to understand now is that if, is this a simple, straightforward answer? No, we cannot amend a couple of weeks ago, we were able to amend because we were going in the more protective direction. We cannot amend and going in a less protective direction because they may want us to engage in whatever this contingency is. And so, undermining what people voted for is really dangerous in so many ways. And I know that we had a lot of public comment on this, but I think it's important also to understand that this is very straightforward as far as Orange County's role in this. We are a party to an agreement that requires all parties in order to amend the agreement. And we can't agree to that based on our charter. We can't continue down the path that they want to go to for this contingency to swap the land because of our charter. So, my question is really, why are we here? The direction should be clear, that we need to defend our charter and defend the decision that the board made, which was that we would no longer support that charter amendment. That was in the protective way. We went in the protective angle. We're allowed to do that. We're not allowed to go in the non-protective angle, and that's under the charter amendment. Everything we've done here since this charter amendment was put into place has been in support of it, and we need to continue to support this. We need to continue to support what was voted on and put in. Now, Osceola County still needs us, even though for some reason in this presentation it appears they don't, right? They still need us because we are still party to the grant award. Now, this is a part there in Tallahassee and listen to them say, this will go back to the counties and the counties have to decide. I thought, bingo, this is awesome. The counties will have to decide. And when it comes back to us, we can only decide in a more protective stance because that's part of our charter agreement. That's in our charter, it's in our Constitution. So I thought we were good to go once it got back to us. And this is why you saw the panic when I said, well, when is this coming back? When is this coming back? When is this coming back? Because when it comes back here, we know we have to abide by this charter amendment so long as it's been upheld in in the eyes of the court or not preempted at the state level. So my question is staff, are you all asking us to undermine our charter amendment by going into a negotiation for this contingency land? I just want everyone to stop when you think you want to say the word donated and ask contingency, because it's not a donation. They're being asked for something, and it's an exchange. This is just, contracts 101. You get something, I get something. You get something, I get something. It's not a donation. We'd love a donated piece of land. We'll take it, right? We'll take it. But if we have to give something up that requires us to undermine our charter, then we're breaking the law. And it's a dereliction of our duty, and we've been entrusted with holding up this charter. So my question is, what is staff asking us to do as far as looking for direction that wouldn't undermine what the voters have asked us to do, which is to only go in a protective direction, not to go in a less protective direction?
We're asking you to provide us direction if you wish us to continue to engage in the process with CFX and Osceola County. If it's, that's it. And whether, based on the 2019 resolution, that you still want to accept the 968 acres. Because in the resolution, that was part of the resolution, and there were several board members, I know you were not on the board at the time, said that one of the overriding reasons that they decided to vote for supporting the resolution was the fact that we would be getting those 968 acres. So,
But that didn't have any impact on the award, the grant agreement, and it hadn't been reviewed by FCT. So it was a resolution, right? It was a resolution to move in that direction.
But we needed that resolution to apply because they needed something in writing per the statute.
100%,
that said
you're saying
that
the same thing I am. You were moving in.
Evaluated it and approved it. So that resolution provided that approval so that we could apply for the linear facilities determination.
Which
along with Osceola County.
Which would inevitably result in less protections for split oak forest. And at the time, that wasn't implicated.
But all those actions occurred prior to the
That's what I'm
passage
saying.
of the
But
charter.
what I'm saying is at this point, the layer that we have is very different now. In directions that we take and we're giving consensus here, right? So if you look at this charter amendment and the language of this charter amendment, that if we give consensus, that's essentially heading in a direction that if it devalues split oak forest, we have violated our charter amendment.
let me try
Commissioner
to
Wilson, I think we need to hear from the
simplify
county
this.
attorney
I
on the
think it's very straightforward.
It is a legal issue, but let's hear from the county attorney. I don't think
Let me try to
Beth is the
simplify
most
this
appropriate
in
person.
making this statement. But for that exception language, we wouldn't be having this discussion at this juncture, I don't believe.
So what do you think
Because-
about the
because-
exception language
Because
It's problematic.
well, yes, it is problematic, but the drafter of this, who represented the Charter Review Commission and drafted this, gave this board a potential out.
by interpreting that contingency land as improving?
Well, no, not by the contingency land, whatever may have come forward. Didn't have to be land, it could be
Under
any
what
other kind of project. It's just whether or not whatever came forward is something that you as a board believed would provide greater, more stringent protections for split oak forest. That's what it says.
Okay, so what it says is the prohibition set forth in
Right.
this section shall not apply to any action,
Right.
negotiation, amendment, modification, agreement, ordinance, or resolution entered into or undertaken by the Orange County Board of County Commissioners which provides greater additional and/or more stringent protections for the wildlife, vegetation, or environment or preservation of the use of split oak forest as conservation land. There's nothing
So-
in there about
Right, so if,
improving transportation.
so if you believe that there's nothing that is currently exists, which is going to provide those greater protections for split oak forest, then guess what?
The charter applies.
Charter applies. The prohibition is there. There's no doubt about that. Now, understand that We are currently involved in litigation.
I get it.
No,
We
I'm
can
just
wait
going
for that,
to
but
say,
we can wait for that.
we're currently involved in litigation,
Yeah.
and we are defending the charter amendment. And we are defending it based upon those agreements which exist, that is a contractual agreement, but yet, and we filed a motion for summary judgment to try and get this matter resolved, because there's no issues about the facts.
Right.
This is just strictly a legal question that's before the court.
Right.
And we, I think last week, got a response to our motion for summary judgment by Osceola County. And so at some point, I don't know when, I don't think we've gotten it scheduled yet for a hearing, we're going to have at least a decision of the lower court with
Yeah.
respect to the viability and validity of the charter amendment. But right now,
Right now,
all you have to decide is that that exception does not apply. There's nothing that is being done currently that provides greater protections or more stringent protections for split oak forests.
but here's my concern, is that if fully agree that exception does not apply, fully agree that the charter amendments language provides clarity of which direction this board goes if we make any direction. My concern is, the way this is being presented today is very clearly, but we don't have any control over what happens in Osceola County, which disregards the original grant agreement. And so,
But I think what's probably occurring here is, yes, that agreement is some of those agreements are tri-party agreements. From my recollection, there's nothing that prohibits them from moving forward with a separate agreement altogether. I mean, in other words, it's not a modification to the agreement. It's two parties going off and making their own agreement.
which
And
they
so-
did anyway.
and
I'm
so-
not,
yeah,
I
yeah,
agree.
yeah.
But-
And so
but-
from my vantage point, what I see is happening is that at each step of the way, Orange County is being cut out of the process.
Yeah, but, so, understanding sort of the position that we're taking and why they want to cut us out of the process. When we look at what they were required to do in order to modify the grant agreement, it required our participation. It required our support. If, when that went in front of the FCT board, they never determined that that was a done deal, cracked open, have at it, how is that not still required of them?
That's a question for FCT to
But,
to
well, and this is
answer,
my
yeah.
issue, right? Because
Yeah.
we haven't gotten some of these answers. I got
And
a
that's
letter
That's the
yesterday.
unknown in all of this.
But
And
that's-
And hopefully we'll know it whenever they meet and give us some indication.
And they, I mean, I got.
But if the past actions are any indication of what they might do in the future, then the picture in terms
But
of.
what they were willing to do in the past was based on an understanding that the parties to the agreement
Yeah.
were all on the same
Yeah.
page. And so I think that we're doing a chicken and egg thing. Because, so in just so that I understand what's happening with FCT,
Mm-hmm.
I did get some correspondence that they have not received information, that they had asked for, even though what we were presented today was that they were no longer asking for it. Now, so I don't know what the status of that is.
They are no longer asking or requiring an amendment to the FCT grant award agreement. What they are waiting for is the information that was required as part of their condition of approval, those 7 points.
So
That package has not been submitted to them.
they are no longer,
Go to slide
This is a-
25. That,
Thank you. Going the wrong way. No. Miles is helping me. Thank you. These are the actions that are remaining. And so we told the board in 2019 that we felt as though the FCT grant award agreement would need to be amended. We also told the board at that time that the interagency agreement over the existing split oak forest would need to be amended. Based on new information, and it was verbal, And we have submitted an email to FCT to request that they put that in writing. We have not received a response.
Okay, so, and I don't know who was their point person or who was the point person
I
here.
personally spoke to Callie DeHaven at the Corridor Connect meeting.
Okay, because the correspondence, this was as of yesterday, this is dated Monday, February 5th, from William McMahon, who,
I personally, we sent an email to Ms. DeHaven on Friday.
okay, so if I can read this from yesterday, thank you for your email. I can confirm that none of the 7 conditions outlined in the April 20th, 2022 agenda item for Split Oak have been satisfied. There has not been any correspondence between FCT and Orange or Osceola counties regarding Split Oak. So I'm
I
not
don't
saying that they don't have
disagree
their own
that.
communications dysfunction over there, but what I'm saying is, as a commissioner who's sitting here being asked for direction, I don't think I can do that, hearing that what I'm getting from staff in their communication with FCT doesn't line up with what FCT is actually just telling us directly on the phone.
And the package meeting those 7 conditions has not been submitted, because all 7 conditions, the information like the release of the conservation easements in Osceola County, the granting of the easement to the 60 acres to CFX, that has not been accomplished yet. But once it's accomplished, it will be submitted to FCT.
So with that,
So you're referring to slide 20.
okay,
I'll check.
why are, but, and I guess I think the other important piece of this is if this is what they need to undo an agreement that we no longer agree with, the action, and they, well, we're hearing a varied report here, because I have information from the project manager that's like, we don't have any of that, and no one's talking to us. Why would we be continuing to spend our resources and time to provide information they need to cut us out?
That's not
Well,
what,
the
Yeah, that's
question
not
is,
what-
do we
yeah.
want to be cut out?
yeah, that's what we're saying today. What we're saying is, if they're saying, and we'll get
They
clarification.
need this to transfer. We do not.
They need some of these from us, not all of this, and that's the point. There are certain things now that they don't need from us. And so it's, get some clarity here on
Yeah,
exactly
and I don't know
what
what
they
that
need
is, because that
for us
doesn't seem to be
or
clear
not.
at all.
That's what the issue, and that's why the purpose of this discussion is says, if they, I hear what you're saying, we need that confirmation between what's verbally committed, what's, someone is saying, I think they're referring to 2 different things. I think they're referring to this versus the other matter, but to get that clarification, if they're going down a path that excludes Orange County, I want to know if the board's comfortable with that, which of course you aren't, but certainly if part of that includes the donated land that Osceola County.
We're not calling it
FCT
donated land. It's contingent. We know it's
Yeah.
not donated. It's not donated because they're asking for something in return. So we have to stop doing that. It's an absolute disservice to the public to hear donated land, because they think that Green Place is some quid pro quo, because that's what they've learned through this process. This is not donated. This is a developer, 2 developers trying to make sure they can get what they want and manipulating a system. It is not donated. It's contingent. My question, though, is, in
So-
order for FCT to formally transfer land out of Split Oak Forest to whoever, or to undo the grant award agreement, they're requiring all the parties to the agreement to satisfy these conditions.
Basically, the first bullet is pending. So if the board provides direction today that we no longer wish to accept those 968 acres, Osceola County is going to say we are accepting all of those 1,550 acres, and that first condition will be satisfied. 2 out of the 3 items on the second condition of approval have, the information has been generated to satisfy that. A title search would be done upon the transfer of the ownership of those lands to Osceola County or Osceola and Orange County if the board decides they still want to accept the 968 acres. Bullet number 3 has to describe how the donated lands will be managed. That would be accomplished by that interagency management agreement that either Osceola County will enter into solely with FWC, or if the board decides that they want to accept those 968 acres, it would be an interagency management agreement between Orange County and FWC to manage those 968 acres, a separate interagency management agreement from Osceola County, or just one with Osceola and FWC. The counties have to provide a revised management plan that to adjust for the linear facility and incorporating the additional property. That is part of those negotiations that need to be held with FWC. The counties must provide the draft easements. Even though it says counties, Osceola County is going to grant 60 acres to CFX for the proposed alignment for the road. They're going to, they have stated they want to maintain the existing easement that they have granted to FWC over their portion of Split Oak over that 100 acres. And they will accept the management responsibility only of those 100 acres. They want to put in an enhanced trail system. I'm just,
No, I know.
I'm giving
I
you
just,
the information.
I know.
So, Commissioner
Osceola
Wilson.
County-
No, I know, and I've dominated your time. I just want to,
Yes, I want to try to get us through the other commissioners, so at least we can maybe do 30 minutes or take a break
understand.
before the 2 o'clock.
And I apologize. I just want to make sure that I'm expressing my position in my ask, okay, is that we do everything possible, not just to uphold this charter amendment, but also to be really clear with our public. I was really concerned about even the bullet points that were articulated that continue to perpetuate that this is only a 60-acre impact. We know it's not. If they're not even willing to, if FWC doesn't want to look at
60
it.
acres of direct impact.
Okay, but I'm just saying,
Okay.
there seems to be some editorial pieces that I want to be super clear that if we're going to go to bat and defend this charter agreement and defend our investment that was made a long time ago and continuing to be made, that we do it full-throated, that we don't do it like, ooh, sorry, Osceola. No, look, I get it. That's over the border. I understand that part of it. But we had a shared agreement. We invested together. We invested over a long term with them. And what's important now is that they don't just toss that away and say, we'll just take it plus some more land in Orange County. That's absurd. That's an absurd position for them to take, that they're just going to take more land in Orange County because of a contingency agreement. So whatever we can do to support you all in defending the charter, in defending our investment, that is where my position is.
All right. I think we all share the position, so let's try to manage the time. Commissioner Bonilla.
All right, I'm going to start with a question. Let's see. Counties must provide a revised management plan adjusted to account for the linear facility and incorporating the additional property into the Split Oak project. That management plan, is that a joint agreement between all parties?
That management plan is generated by FWC. There's a current management plan, and they take that management plan for approval to their ARC committee. Orange County, I'd have to double check, but I don't believe that we signed that management plan. That management plan is generated by FWC because they are the land managers.
Okay, the letter from Byron Brooks was, please accept the following as a request from Orange County for a management plan modification to allow for the construction of a linear facility on FCT project, blah, 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 as known, and it goes on. So this letter from Byron, we had requested a modification of this management plan.
That was a requirement of the statute
Okay.
for a linear facility determination.
All right, and the vote on November 28, 2023, and it's on your slide, the board voted 6-1 to approve a motion that, given the prior charter amendment vote of 2020, the board no longer supports the pending application before the Florida Fish and Wildlife Conservation Commission and Florida Communities Trust. So, you know, I got a copy of that email too, and I actually passed it around with some other documentations to everyone. And where is it? It was just here. It said, there has not been any correspondence between FCT and Orange Osceola counties regarding Split Oak. Again, I don't know what's going on with their communications either, but when we're being told that these agreements signed by all parties over this land doesn't have to be modified anymore, and, you know, we don't have to be a part of that, and you heard it from 2 people in the hallway, but there's no written record of that.
I didn't hear it from 2 people in the hallway.
You spoke with
I
them.
spoke to Kelly DeHaven.
Yeah,
And
that's
I
you
asked her
speaking with
what
them.
Huh?
Yeah,
I
you're
spoke
hearing,
to her.
I'm saying you're hearing it, you spoke with them in the hallway and, or
No,
where it was, the
it was at a
meeting, or
meeting.
where it was. But there's no record of this.
And based on your request, we have sent an email to Ms. DeHaven to confirm those facts in writing.
Have you received a response?
No.
Okay. And I really just find it funny, because we called, right? We didn't email? No, we just called them, but haven't gotten a response. But why are they responding so much faster to a resident than to Orange County? Because this was sent on, it's all right. So, I mean, it was sent
I would
on
ask
the
that
5th.
you not refrain from speaking. I understand.
It's
but
okay. We don't need to
Right now,
name
the
you.
conversation is just between us, if you don't mind, just for a point of order. I understand.
It's okay, I have the email here, and I already passed it out to everybody. So this was sent, I mean, yeah, it was within 24 hours, like, they responded to her. And responded with, there has not been any correspondence between FCT and Orange and Osceola counties regarding Split Oak. But we can't get a confirmation by email that we don't need these agreements anymore. That's concerning. And again, like, look, I'm not saying that you're lying, because, you know, I don't know what happened. You know, I don't know if it's them, I don't know. I'm not going to accuse anyone of anything, because I don't have all the information. But what I'm saying is that we don't have all the information. You know, so we're being told these things, though, without anything in writing, any confirmation about these things, you know, being true. And we have a contract, and I think, I'm not going to try to quote you, but, you know, you said something, you mentioned the agreements, the 2 agreements that were party to it, and those have to be, they still stand.
That's our argument.
Yeah. And so what I find concerning, and I think, you know, Commissioner Wilson had alluded to this, and I'm not trying to put, is that I agree with everything you said, County Attorney. But the presentation we're getting is just something else. And it seems, I feel like I'm being manipulated here, and not just from you, Beth, but from the developer, from CFX, from Osceola County, like from all parties here, because, I mean, there's so much wrong here with this land swap. First of all, I mean, nowhere in this presentation did I hear anything about Roberts Island Slough. Can you tell us a little bit about Roberts Island Slough that's part of this 900 acres that's in Orange County?
Roberts Island Slough is the eastern boundary of the proposed 968 acres.
And what is it?
It's a wetland.
Yes.
It's a slough. It's a slough that provides conveyance of water. It would help to attenuate flood water. It would help to potentially recharge our aquifer, provide water quality benefits.
And with our wetlands ordinance, do you think that that would be impacted? Do you think that the board will allow that to be developed into urban densities? Like the developer said, if we don't do this land swap, he doesn't get what he wants, he's going to develop all of it urban.
I don't speak for the board.
Okay,
Commissioner Bonilla.
well, okay, the board members here
If
can,
the item came to the board, that would be the board's decision, whether they would support those type of impacts or not.
exactly. So, first of all, the majority of this property is wetlands that, under the wetland ordinance, would already be protected. There's the other 200 acres in here that is what, I know the Lake Mary Jane had mentioned as uplands. Tell me a little bit about that property.
The 230 acres that you're referring to
Mm-hmm.
are considered rural communities. They were historically an orange grove and an improved pasture.
Okay, so what
And
is
those
the
would be
environmental?
the lands that would potentially have to be restored,
Mm-hmm.
both hydrologically as well as the habitat.
Okay, is there any contamination and pollution on these properties?
There was a Phase 1 done on the property. The Phase 1 found one site on Orange County that had been contaminated, but it had been cleaned up. There is a known cattle vat on a portion of the Osceola County, 582 acres. I do believe they have had that cleaned up as well. So the Phase 1 was reviewed by our risk management folks. Obviously, another one would need to be done if the board decided that they wanted to own those 968 acres. But there was a Phase 1 done.
All right, so these 200 acres are not valuable conservation lands. It's already in the rural service area zoned for one house per 10 acres. And, you know, we had the Lake Mary Jane residents come here and speak. And what was it that, I can't remember what one of the guys were saying that, oh, you know, the voters didn't get all the information they needed to make this vote, this choice. However, he didn't give us all the information either, because there's an agreement between Lake Mary Jane and Tavistock to prevent high-density urban development on this 900 acres. And it also states that there would be a wildlife corridor through there. So basically, we don't need this 900 acres swapped, because it already has what we need it to have. It's going to be protected wetlands. It's going to have the wildlife corridor. I'm a little bit concerned about that corridor, though, because it's like far from any other connecting properties. But, you know, we need to do what we can. Oh, also one more thing, which really, you know, kind of bothers me. But, you know, it's stated that this property is within the, what is it called? The state's wildlife corridor.
Critical linkage.
Critical, okay. So what properties are included in that critical corridor? Where is this?
That particular linkage information is statewide. They look at different things and determine priority of how it would be a linkage between existing for wildlife.
Okay. Now, the reason why I bring this up
And that's
is,
developed by the state.
yes, and the reason why I bring this up is because this, you know, the way it's just presented, you know, it's like presenting a house. You know, this house is just so amazing. Like you have to buy this house right here because it's in the perfect neighborhood that has this and that and whatever. And then you buy the house, it turns out that the whole, like, county, whatever, has those same amenities and benefits, and you could have bought the house maybe someplace else cheaper, whatever. But, you know, this right here that I handed out to you all, that critical area of wildlife corridor is mostly almost all of East Orange County. So almost all of East Orange County is a critical wildlife corridor. Unfortunately, though, we do have the Innovation Way overlay, which is going to be developing most of it. Well, not most of it, some of it. But it's going to be disturbing some of the wildlife corridors that, we should have in the county. So that's decisions that, previous boards have made, that was made before us. But, recommended. So, and this is just, it's manipulation by the developer to this county for lands that's already protected. So, no, I don't think we need to give direction to the staff to go ahead and, make this land swap. And I just feel that some of these things that we're being asked to do as well, we were pretty clear. I mean, the board voted, the board no longer supports the pending application before the Florida Fish and Wildlife Conservation Commission and Florida Communities Trust. Has there been a letter that went to the Florida Communities Trust telling them that we no longer support this modification? Yeah? Okay, thank you.
Yes, that was communicated. The
Pardon?
board action, you communicated that to.
That
the
was
floor.
communicated at the FWC meeting.
Okay,
Okay,
but has anyone
FCWC.
communicated this to FCT?
She said to FCT, was that communicated to FCT?
No.
How long do we need to wait for that to happen?
I'm sure they're well aware
could-
of it, but
that
we
could be
can,
said-
so,
yeah,
I mean,
that
that's
could
why
be said to
they're
FCT.
doing what they're doing. But, Byron, we can follow up. Commissioner Scott has something, and just trying to manage our time. Do you have final comments?
I think my final comment was that we don't need to be tricked into a land swap.
Okay, all right.
And that's, Mayor, because that may help with the rest of the conversation, because I think there may be, well, just to be sure there's some clarity here. If the boards, and that's what we're looking, the board says, look, don't engage, tell Osceola County, no, we defend, that's fine. We didn't want to be in a position where we were privy to communication that Osceola County and FWC or FCT was working on an alternative proposal that might cut the board out in some way, particularly associated with the land as well. And that's why we just wanted to have a conversation. The board is saying very clearly that, we stay the ground, stay the course, don't provide any information, don't engage. That's why one of those items said, if you don't want us to engage, we don't engage. But we didn't want to be in a position where not only did Beth hear from the Osceola county manager called me as well and conveyed these same points. So we have heard from Osceola County in some respects in terms of what they were working on. We didn't want to be in a position where you all weren't aware of that and can give us direction. If the deal is board saying, and don't engage, don't provide anything needed, we're good. So I just want to be sure there
Before we
wasn't
get
any
there, Byron,
misunderstanding.
let me just go to Commissioner Scott, and give him the opportunity to be heard, and then we'll kind of come to a conclusion.
There certainly could be more clarity on this issue. One thing is clear, the voters did vote for a particular action, and I think we're duty bound to uphold it the best of our ability. So I am in 100% agreement with that. The confusion, at least for me, is there were several decisions and agreements that were made prior to the passage of the amendment or
The charter
review amendment, and so that is a point of confusion for me in terms of clarity. I mean, I get the nuances and times, and I think back to what Commissioner Wilson said in another meeting, that we as an entity, when we enter into an agreement with anyone, we want to know that we honor our contractual agreements. And so, for me, I would think as an organization, we want to at least be in the room and anything that may impact us directly or indirectly. But if we, continue down the path, we've already passed a resolution withdrawing our support, and we just don't do anything, and then, sometime down the line, we recognize, hey, maybe not doing anything caused a negative harm. Did we do the best of our ability to support the voters? It isn't real clear to me the impacts of the charter amendment on agreements that were already made. what is clear is that, we don't do anything forward, but how does that apply to, and I don't know if, Jeff, you can provide clarity, how does that apply to things that are kind of in motion? When you enter into any agreement, there are some, initial steps and subsequent steps based on that agreement. And so the charter review says, or charter amendment says, okay, we don't enter it, we have to respect the early votes, all that. But the train already was going down the track. So it's like, okay, do we stop the train? Like, okay, or it's like, do we stop the train that's already going, or based on the charter review? Or do we not send any new trains based on, you know what I'm saying? Like, it's just, these are things we're all in emotion. So that's the confusion for me. And why I had hesitancy when we had the last vote, so.
The choice is be there at all these meetings that takes place, whether it's FWC or FCT, and listen to what's being said, but let it be known that you're not supportive of anything that would facilitate what may ultimately happen anyway, which is the construction of the linear facility.
Right.
Okay.
Thank you for that clarification, Mayor. I'm good.
Commissioner Moore.
And that's what I was going to say, was that certainly to honor the vote that you all made the last time, we don't have to agree to any of that, but I don't certainly want to give Orange County land over to Osceola County. I mean, and I think that's where the rub is here, is that I understand it was a joint agreement, but I don't feel as an Orange County Commissioner that I can control what happens in Osceola, and I certainly don't want them controlling what happens in mine. So I would certainly move to make sure that we manage that land, because I believe we'll do it better. And I don't see it as a swap, because I still see that you can stand by what you've been saying, and whatever FCT and FWC are going to do, they're going to do. They know how this board feels, but I don't want to give my land to Osceola County. Thank you.
Okay.
Point of order, was that a motion or was that just your comments? Because you said I certainly moved to support, so I'm trying to understand. Were you just making your
I
comments?
was just commenting. If you were ready to make a motion, I can.
Okay. And so I think the consensus that I'm hearing at this point is stay the course, not engage unless something changes. Okay. Now, if we hear something back from the courts because of the pending litigation, then I think it's incumbent upon the county attorney and county administration to apprise us, because we may have to take some action pursuant to that. Or if we get some communication in writing from FWC or FCT that is problematic for us, then the board needs to meet and discuss what we do from that point forward. But at this point, it's stay the course.
And just for clarification, that includes making sure that if they're requiring us to do something, survey, assessment, whatever it is, in order to undo the protections, that we're not moving in that direction. Because that is a critical piece, right? They need.
I think we're clear.
I just want to make sure that we're all,
clear,
okay.
Commissioner.
Okay.
However, even if they do that, we need to bring it back to the board and have a conversation.
Right.
And that's what we're saying at this point.
And I just wanted to let you know, Mayor, that the hearing on the motion for summary judgment is scheduled for February 19th.
Okay. So, there'll be some updates. So at this point, I think we're saying the same thing. We're clear. I just want to make sure that between county administration, our team, Beth, the county attorneys, we're all clear what is being said here. If not, then we need to try to clarify before we break. Are we clear? Are you all clear? Okay. Are you clear, Beth?
I do believe you're providing direction that Orange County staff no longer engage with the conversations with CFX, Osceola County, and FWC.
Okay.
I think they say they want us in the room.
You need to be in the room, but you're not.
But right.
But just-
Do we want to be in the room or not?
Yeah, they want us in
We
the room.
want you in the room. Do we,
Yes.
any questions by members of the board?
Yeah,
Any questions by
Okay.
the controller? You got what we're saying, okay. All right, so with that, then we're all on one accord. We're going to go into recess until the 2 p.m. afternoon portion of the board meeting. So we're in recess. Thank you.